Welcome, deep divers. Imagine for a moment a world where just a single phrase, maybe one carefully chosen word, could actually, ripple through history, change a nation's entire destiny.
Yeah, it sounds dramatic, but it's real.
It is. And that's the extraordinary power we're exploring today. This profound idea that language, especially when it's used strategically, isn't just about communication. It's a monumental force.
Absolutely. Think about iconic speeches or even the wording of laws. Every word matters.
Right, like Dr. King's I Have a Dream, or even the debates over every single clause in the U.S. Constitution. Each word chosen, each argument made, even a dissenting voice raising an objection, it can fundamentally alter our collective path.
And that brings us right to the heart of today's deep dive.
Exactly. Our mission today is to explore precisely that. How Justice Ruth Bader Ginsburg, a true titan of American law, used the sheer power of language in her judicial opinions, her speeches, and maybe most famously, her eloquent, often prophetic dissents to really profoundly influence the United States.
It's a career really defined by words, each one chosen with such precision.
Surgical precision, yeah. And each one intended to make an impact far beyond just its immediate context. She was often speaking directly to the future, wasn't she?
That's the key, I think. What's crucial to understanding Justice Ginsburg's approach is her unwavering eye towards future generations. She wasn't just, settling disputes for the present moment.
Yeah.
She was actively planting seeds for future legal and social evolution. This whole philosophy, some people call it dissenting for the future, it meant crafting opinions, even when she was in the minority, that laid down this compelling intellectual and, moral groundwork for progress that might only come years, maybe even decades later.
So she knew her audience wasn't just the current court.
Exactly. She understood some battles are fought not just for the immediate win, but in print, for an audience that might not even be born yet. Future lawyers, future legislators, future Supreme Courts even. Her words were, in a way, a form of strategic advocacy, designed to persuade and, crucially, to endure.
That's a really powerful way to frame her legacy. And throughout this deep dive, you'll gain some truly surprising insights into the Supreme Court's intricate inner workings. Insights that really illuminate how a single justice can exert such profound influence. We'll uncover the remarkable figures who inspired her, delve into the meticulous thought, the strategic intent behind every phrase she penned, and trace the fascinating evolution of her public voice.
From her judicial philosophy right through to her most impactful dissents.
Yeah. Prepare for a journey into the mind of a legal luminary whose quiet yet incredibly well-articulated voice became one of the most powerful in modern history. We're going to see how she built this lasting legacy, word by carefully chosen word. Aye, the shoulders she stood on, paving the way for equality. So to really understand Justice Ginsburg, we first have to appreciate the path forged by those who came before her. These pioneers, right? The shoulders she so gratefully stood on.
Absolutely. Context is everything.
And when we look at her own collected writings, one figure just emerges with this particular brilliance and tenacity. A really remarkable woman named Belva Ann Lockwood.
Lockwood, yeah. Ginsburg herself called her a woman of courage who would not be put down.
And that wasn't just a casual compliment, was it? It feels like a deep recognition of maybe a kindred spirit.
I think so. Lockwood's life story is pretty incredible.
It really is. Born in rural New York way back in 1830, her early life was already a testament to resilience, kind of foreshadowing the tenacity she'd show later.
Widowed very young, right?
Yeah, just 22 with a young child to support. This is after only 4 years of marriage. And she didn't just succumb to the incredibly restrictive norms for women back then.
No, she pushed back.
She chose to educate herself, became one of the earliest female college graduates in the country, pursued a career as a high school teacher, then a school principal, always pushing against those limited opportunities.
But her ambitions went further.
Oh yeah, as Ginsburg recognized, they stretched far beyond the classroom. She moved to Washington, D.C. in 1866, quickly became a prominent suffragist, a fierce advocate for widening employment opportunities for women. And this deeply held conviction, it inevitably led to this, audacious ambition to become a lawyer.
In an era when that was almost unheard of for a woman, often legally impossible.
Exactly. She was denied entry to law school multiple times before finally getting admitted. And even then, they initially withheld her degree.
Unbelievable.
She literally had to appeal directly to the President of the United States at the time, Ulysses S. Grant. He was also the ex officio president of the school, just to get her diploma.
The sheer determination. And her achievements, well, they were nothing short of revolutionary. They fundamentally altered the landscape for women in law.
Tell us about that. How did she break through?
Well, in 1879, after facing repeated rejections and actually needing specific legislation passed just to enable her, she became the very first woman ever admitted to the U.S. Supreme Court's bar.
The first woman. That's huge.
It's monumental. This wasn't just symbolic. It was a direct challenge to the deeply entrenched, male-dominated legal establishment of the late 19th century, a system that actively excluded women.
You have to imagine the sheer audacity, the courage needed, not just to endure that resistance, but to overcome it, to force open the doors of such a powerful institution.
And she didn't just get in. She then became the first woman to argue a case before the 9 justices, an absolutely unprecedented event.
Wow. And didn't she also run for president?
She did. Perhaps most strikingly for her time, she was the first woman to run a full presidential campaign. Did it twice, actually, in the 1880s.
Incredible. Ginsburg noted that Lockwood's persistence directly led the U.S. Supreme Court to change its ways. That change wasn't accidental, was it?
Not at all. It was the result of relentless individual will. Lockwood's legal arguments, her very presence, chipped away at that institutional misogyny. It set a vital precedent, opened doors for countless women in law who would follow, including Justice Ginsburg herself.
It just profoundly demonstrates that these fundamental shifts in institutions, they often begin with the relentless will and, frankly, courageous acts of pioneering individuals.
Exactly. The power of one determined person.
It's incredible to consider Lockwood's tenacity.
Yeah.
And it really highlights Justice Ginsburg's understanding that her own journey was part of this larger, cumulative effort.
Yes, she was very conscious of that.
She consistently made a point of paying tribute to these unsung heroines, these other way pavers,
Yeah.
people who contributed to women's advancement in law, many who maybe didn't make the front page but were absolutely crucial.
She wasn't just recognizing individual brilliance, she was acknowledging a collective struggle, a shared history.
And this practice, acknowledging that collective effort, it demonstrates her deep understanding. The significant societal change is never the work of just one person alone. It builds, right? Brick by brick on the often unseen contributions of many.
Ginsburg, for instance, gave these powerful remarks at the American Sociological Association annual meeting back in 2006. And there, she credited Cynthia Epstein's groundbreaking work on women in law.
Okay.
Ginsburg even noted she herself had mined Epstein's research as a source for her own historical understanding. And in those remarks, she didn't just mention 1 or 2 names.
Oh, she was meticulous.
Incredibly meticulous. She listed figures like Arabella Mansfield, 1869, first woman admitted to a state bar in Iowa after a court ruled a state law limiting practice to males was invalid, or Lemma Barkaloo, among the first women to even attend law school in the U.S., also 1869.
Wow, these names need to be remembered.
Absolutely. Micah Bradwell, who fought for years to practice law in Illinois and at the Supreme Court, despite being denied just based on her gender and marital status. Then you have Barbara Natrebe Armstrong, the first woman tenured law professor at a major university.
That's a huge milestone.
It is. Florence Ellenwood Allen, first woman appointed to a federal appellate court. Bernita Shelton Matthews, first woman federal district judge. And Shirley Mount Hufstedler, who served on the Ninth Circuit Court of Appeals before becoming the first U.S. Secretary of Education.
It's quite a list.
It is. And this meticulous acknowledgement, it's crucial for maintaining that historical narrative, for inspiring future generations. It reminds us that progress is like a relay race, not a solo sprint.
It really makes you reflect on how the visibility of women's voices has evolved over time, even when those voices were connected to powerful men. Justice Ginsburg's own words help draw a fascinating contrast here.
How so?
Well, consider Malvina Shanklin Harlan, wife of the first Justice John Harlan. She wrote this really engaging memoir detailing her life, the court's inner workings during her husband's time there. But it just languished, as Ginsburg put it, for too long, barely noticed, among her husband's papers in the Library of Congress.
That's such a shame. Think of the insights lost, or at least delayed.
Exactly. It's a poignant reminder of how many valuable voices, just brimming with unique insights, might have been lost or significantly delayed in reaching the public eye, simply due to the era's biases against women's intellectual contributions.
Right. Now compare that to Helen Herron Taft, born about a quarter century after Malvina Harlan. Her book, Recollections of Full Years, had a very different trajectory, much more visible.
Okay, what was different?
Her manuscript didn't languish in obscurity. Her husband, William Howard Taft, who was not only president but later Chief Justice, and their daughter, Helen Taft Manning, actively arranged attractive terms for its publication.
So they supported its publication.
Actively. They saw it partly as a way to help her overcome what they delicately called post-White House blues, but it also showed a clear understanding of the value of her perspective. Helen Taft's book, published in 1914, actually sold quite well.
So, when Justice Ginsburg looked at these contrasting lives, what conclusions did she draw about why some voices reach the public and others languish? What does it tell us about the forces, beyond just talent, that shape historical recognition?
Well, it wasn't necessarily the content itself that differed so much. It was the surrounding circumstances, the timing, the social context, and crucially, the personal advocacy.
The context.
Exactly. By 1914, think about it, the women's suffrage movement had become this vibrant national force. There was a growing appetite, a market even, for women's perspectives and experiences that simply wasn't there in Malvina Harlan's time.
Right. The social movement created an opening.
Precisely. This contrast in narrative highlights how visibility for women's voices, even those connected to powerful men, was heavily influenced by the prevailing social movements and the personal, often strategic support behind them.
So recognition isn't automatic.
Far from it. It's often a product of an opportune moment, a supportive environment, and persistent effort to bring those voices forward. And this understanding undoubtedly shaped Ginsburg's own strategic use of her platform later on. 2. Inside the highest court. RBG's judicial philosophy and strategy.
Okay, so these incredible women paved the way, showing the power of persistence, of individual will. Justice Ginsburg understood this legacy intimately, and she brought that same strategic foresight to her own work within the unique, often quite rigid landscape of the U.S. Supreme Court.
And it is a unique landscape.
Absolutely. It's crucial to understand, as you listen, that the Supreme Court is not, as jurists say, an error correction instance. It's not just about fixing mistakes a lower court might have made in applying the law to specific facts.
Right, that's a common misconception.
It is. That job actually belongs to the federal courts of appeals and state appellate courts within the, 52 judicial systems across the U.S. They handle the vast majority of appeals, ensuring the law is correctly applied in individual cases.
So what is the Supreme Court's main job then?
The Supreme Court has a much more specific and, frankly, more profound role. It primarily considers cases presenting what are called deep splits.
Deep splits.
Okay. That means questions of federal law where different courts could be federal, state, or a mix have strongly disagreed. Imagine two different federal appeals courts, say one in California and one in New York, interpreting the same federal environmental law in completely opposite ways.
Creates chaos for anyone operating nationwide.
Exactly. Businesses are left in limbo, unable to comply consistently. That's a deep split, and that's precisely where the Supreme Court steps in to provide a single, consistent interpretation for the entire country.
So they're resolving fundamental conflicts in the law.
Precisely. These deep splits make up about 70% of the court's docket. And understanding this distinction is vital because it sets the stage for appreciating the significance, the strategic intent behind Justice Ginsburg's interventions. The court isn't there to relitigate every misstep. It's there to resolve fundamental legal disagreements affecting the whole nation, shaping the very definition of federal law.
And what's fascinating here is Ginsburg's really clear-eyed understanding of the court's fundamental limitations and its actual power within the American system.
Right. The limits are important.
Hugely important. She firmly believed the court has prestige to persuade, but not physical power to enforce. She even echoed President Andrew Jackson's famous, maybe apocryphal quip about a Supreme Court decision he disliked. The Chief Justice has made his decision, now let him enforce it.
Yeah, that quote says a lot.
It really does. This perspective highlights a delicate but critical balance the court must maintain. Its authority isn't backed by an army or police force. Its legitimacy, its effectiveness rests entirely on public and political acceptance, and ultimately on the executive branch choosing to enforce its mandates.
So it relies on persuasion and acceptance.
Fundamentally. And from this understanding of the court's institutional constraints, Ginsburg concluded that justices generally follow, they do not lead, changes taking place elsewhere in society.
That sounds almost passive.
Well, it isn't to say they're passive or lack influence, but rather that their most effective and crucially legitimate role is to reinforce or signal a green light for a social change through what she called temperate decision-making.
Temperate decision-making.
Right. Rather than trying to impose radical, sweeping changes that society isn't yet ready for, such judicial overreach, in her view, could provoke a backlash too forceful to contain, ultimately hindering the very progress it sought to achieve.
So it's a pragmatic view.
Very pragmatic, a recognition that the court's power, while immense, is also fragile and depends heavily on societal buy-in.
A perfect illustration of this reinforcer role seems to be the landmark decision in Loving v. Virginia, 1967.
Absolutely.
This case struck down state bans on interracial marriage, effectively declaring separate but equal dead for racial classifications everywhere in the U.S. Monumental ruling, absolutely essential for civil rights. But it didn't come out of a vacuum, did it?
Not at all. It reinforced an existing, albeit slow, social change that was already underway. Over a dozen states had already repealed their anti-miscegenation laws in the decades leading up to Loving.
So society was already moving gradually.
Exactly. The court gave this clear, definitive green light to a societal shift that was gradually taking root. It wasn't unilaterally initiating a change for which there was no prior social movement or growing acceptance.
Which shows how the court operates within those perceived boundaries of public sentiment to ensure its legitimacy and, critically, to ensure its decisions can actually be implemented and accepted.
Precisely. It's a delicate dance.
Now, here's where it gets really interesting, and this might be an aha moment for many of you listening. Justice Ginsburg's nuanced critique of Roe v. Wade, the 1973 decision establishing a woman's right to an abortion.
Yeah, this often surprises people.
It does. Because while she was a lifelong, staunch advocate for reproductive autonomy and gender equality, she held this, well, surprising perspective on Roe's strategic impact. She believed the decision halted a political process that was moving in a reform direction and thereby prolonged divisiveness and deferred stable settlement of the issue.
It's an incredibly insightful perspective, though often misunderstood, but it reveals a core part of her judicial philosophy. This preference for gradual, legislatively driven social change over sweeping, judicially imposed pronouncements, even for causes she deeply, deeply supported.
So she preferred change through legislatures.
Generally, yes, for long-term stability. Before Roe, there was actually a pretty robust political movement in various states to liberalize abortion laws. New York, California, Hawaii, Alaska, for instance, had already repealed or significantly reformed their abortion statute.
Right, change was happening state by state.
Exactly. Legislatures across the country were actively debating and moving on the issue. Ginsburg's argument was that by issuing such a broad constitutional ruling, Roe essentially took the issue out of that democratic process. It cut short this burgeoning legislative consensus.
And the consequence of that?
Well, she believed it allowed opponents of abortion rights to galvanize much more effectively. They could focus all their efforts on overturning Roe, this single judicial decision, rather than engaging in those incremental legislative battles that had previously been moving, generally, in a reform direction. The result, in her view, was a prolonged, deeply entrenched cultural war, precisely because the issue wasn't allowed to reach a more stable legislative settlement.
Wow. So the sweeping victory potentially backfires strategically, in her view.
That was her concern. And if we connect this to the bigger picture, Ginsburg observed that the later Planned Parenthood v. Casey decision in 1992, which retreats from Roe by allowing states to impose more restrictions like waiting periods or parental consent, ironically, may have had a sanguine effect.
Sanguine.
Meaning a positive, beneficial, maybe even oddly comforting effect, in the sense that it revitalized the political movement for reproductive rights that had been so active back in the early 1970s.
So the setback re-energized the political fight.
That was her observation. She saw that the perceived setback from the court could re-energize grassroots political action, forcing advocates to return to the legislative arena, return to public persuasion. Her analysis wasn't about whether Roe was right legally in its outcome. It was about whether its timing and its scope were strategically optimal for achieving lasting, broadly accepted social change.
It raises a really important question then. Can judicial boldness sometimes, counterintuitively, hinder the very progress it seeks to advance by short-circuiting a more gradual and potentially more stable political evolution?
It's a critical, often uncomfortable lens through which to view these monumental legal decisions. It forces us to consider not just the justice of an outcome, but the long-term strategy for achieving it.
That's a truly remarkable and complex viewpoint, especially coming from someone so committed to gender equality. I mean, for many, Roe was seen as this absolute unmitigated victory, From Ginsburg's perspective, what was the specific danger of that judicial boldness? And did she ever acknowledge the counter-argument that, well, without judicial intervention, some states might never have moved towards reform, leaving many women in dire situations?
Oh, she certainly did. She wasn't arguing against the outcome per se, not at all. It was the method. The danger she saw was the creation of this constitutional right that felt perhaps imposed rather than evolved from a broader societal consensus that made it vulnerable to attack, resistant to popular acceptance.
Right, easier to frame as activist judges.
Exactly. When a right is established through legislative compromise, it often has a more solid foundation because it reflects, however imperfectly, the will of the people expressed through their representatives. A sweeping judicial decree, by contrast, can be perceived as judicial overreach and become a powerful rallying cry for opposition, precisely what happened with Roe.
And the point about states lagging behind.
Yes, she was acutely aware that some states would have lagged, but her view seemed to be that sustained political pressure, building incrementally, might have ultimately yielded a more stable and less divisive national framework, albeit perhaps more slowly. It was a calculation, really. Long-term stability versus immediate comprehensive victory. She understood that sometimes winning too much, too fast, can invite a powerful and lasting backlash. 3. Finding her voice. The art of the dissent.
This fascinating perspective on Roe just underscores Ginsburg's long-term strategic thinking. But what happens when the court's path diverged so sharply from her vision that, temperate decision-making or reinforcing a societal trend just wasn't an option anymore?
Well, that's where she truly mastered the art of the dissent.
Right, transforming it into this powerful instrument for the future. And her evolving use of the bench dissent became a real signature move.
Can you explain what a bench dissent is exactly?
Sure. This is when a dissenting justice doesn't just issue a written disagreement, which is standard. They actually deliver an oral summary of their dissent directly from the bench in the courtroom.
So it's a public declaration right there and then.
Exactly. It's not common practice. It's reserved for cases where the divide is especially deep and the case especially consequential. It serves a critical function, highlights the importance of the disagreement for the public, signals the profound nature of the ideological rift on the court, and, crucially, lays groundwork for future legal development. It's a direct address to the nation and, importantly, to future courts.
And what's truly fascinating here is Ginsburg's transformation in her use of bench dissents. During her years on the Rehnquist court, that's 1993 to 2005, her bench dissents were relatively few and far between. Just 6 and 12 terms. It wasn't her primary way of disagreeing.
Okay, so it wasn't her go-to move initially.
Not at all. But this pattern changed dramatically with the advent of the Roberts Court, which took a decidedly more conservative turn. In the 2006-07 term alone, she delivered 2 bench dissents. It even made the front page of the New York Times.
Wow.
Yeah. Linda Greenhouse, the Times veteran Supreme Court reporter, presciently observed back in 2007 that oral dissent has not been, until now, Justice Ginsburg's style, adding that Ginsburg found her voice and used it.
Found her voice. That's powerful.
It was a deliberate strategic choice. By 2014, Ginsburg had delivered 12 bench dissents, making her the Roberts Court's most frequent bench dissenter, including a record 4 in just the 2012-13 term alone.
So she embraced it as a key tool.
Absolutely. This strategic choice, elevating a dissent from the written page to a public spoken declaration, it underscored its role as that dissenting for the future mechanism. She was signaling to the world the profound importance of her disagreement and the potential, often negative, future implications of the majority's ruling. It was her way to raise an alarm, plant a flag, and speak directly to history.
And some of her most powerful dissents directly challenged what she unflinchingly called ancient notions about women's place in society. Let's look at a particularly controversial ruling related to reproductive autonomy, the case of Burwell v. Hobby Lobby in 2014.
Ah, yes, Hobby Lobby, a big one.
Huge. This decision involved a clash between the First Amendment's free speech guarantee, the old saying, your right to swing your arms ends just where the other person's nose begins, and the Free Exercise Clause, specifically concerning contraceptive coverage regulations under the Affordable Care Act.
Right, the ACA mandate.
Exactly. The court's majority ruled that certain for-profit corporations could deny their employees contraception coverage based on the religious objections of the company's owners. This effectively reversed lower federal court judgments and, as Ginsburg put it, blessed a prohibition with no exception protecting a woman's health.
And Ginsburg's dissent was scathing.
Tell us about her core argument there.
Well, her core argument in her Hobby Lobby dissent was just unequivocal. It cut right to the heart of the matter. She insisted that, and I'm quoting here, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives.
A principle Congress had recognized in the ACA.
Precisely. By mandating that contraception coverage, she pointed out that access to contraception isn't merely a matter of health, it's a fundamental prerequisite for women's equal participation in society. Full stop.
And her critique of the court's reasoning.
It was particularly sharp regarding the court's justification. The majority ostensibly claimed it was okay to allow employers to deny comprehensive health coverage for these deeply personal decisions, partly framed around religious freedom. Ginsburg powerfully argued that this rationale recalled, quote, ancient notions about women's place in society and under the Constitution ideas that have long since been discredited.
Ancient notions, what did she mean by that?
She was referring to historical legal doctrines, historical ways of thinking that confined women to the domestic sphere, denied them control over their own bodies, treated them as secondary citizens whose choices could be dictated by others, employers, husbands, the state.
It raises that important question, doesn't it? How often do seemingly neutral legal arguments or claims of religious freedom actually mask these deeply ingrained, outdated societal views that disproportionately impact one group?
Exactly. Her dissent served as this potent reminder that abstract legal decisions have profound impacts on individual autonomy, health, well-being. She pushed back against the idea that the court knows best for women, or that one person's religious beliefs can justify infringing on the fundamental rights and health needs of others. She was challenging the very foundation of unequal treatment, even when it was dressed up in modern legal clothes.
It's a really chilling reminder of how seemingly settled issues can be relitigated, and how fundamental principles like autonomy can be eroded by judicial interpretation. You mentioned her defense of workplace equality, and she showed a similar unwavering commitment in her dissents there too, highlighting what she called a crucial disregard for the realities of the workplace by the majority.
Yes, another key area for her.
Let's look at another significant case, Vance v. Ball State University in 2013. In that ruling, the majority adopted a very, very narrow definition of a supervisor for the purposes of holding an employer liable for harassment.
How narrow.
They essentially ranked a lead worker, someone who assigns daily tasks, directs workflow, but maybe doesn't have the power to hire or fire, as merely a coworker.
Yeah.
Not someone with true supervisory authority under the law for harassment liability.
Okay, that seems like a technical distinction, but I imagine it had big consequences.
Huge. This specific, seemingly technical legal definition had enormous and immediate practical implications for victims of harassment. Ginsburg's dissenting view was powerful because it directly challenged this narrow interpretation. She argued it ignored the actual power dynamics in most workplaces.
What does she say specifically?
She stated flatly that the majority decision showed disregard for the realities of the workplace and would leave many victims of workplace harassment without an effective remedy under federal law.
So it weakened protections.
Significantly. If we connect this to the bigger picture, this ruling diminished Title VII's capacity to prevent and redress discriminatory conduct. Title VII being the foundational federal law prohibiting workplace discrimination based on race, color, religion, sex, national origin.
And what was the principle she was defending?
Her dissent highlighted a crucial principle. In-charge employees authorized to assign and control subordinate employees' daily work are aided in accomplishing their harassment by the superintending position in which their employer places them, and for that reason, the employer is properly held responsible for the misconduct. Okay. Authority equals responsibility, regardless of title.
Precisely. She was arguing that the employer is responsible for the environment they create and the authority they delegate, even if that authority doesn't come with the official title of supervisor. This case brilliantly demonstrates how judicial interpretations of seemingly minor details, like the definition of supervisor, can have widespread and devastating effects on everyday working conditions and the pursuit of justice. It showed her keen awareness of how legal theory translates into lived experience and, unfortunately, sometimes injustice.
So she's essentially saying, look, you don't need a fancy title to wield power over someone in the workplace, and employers need to be accountable for that reality. It's a profound observation about the difference between maybe legal fictions and actual lived experience.
Yeah.
Speaks volumes about her commitment to practical justice.
Absolutely. Grounded in reality. 4. A dialogue of differences, sparring with Scalia and beyond.
Okay, moving from the power of a single dissenting voice to the complex dynamics within the court, let's explore one of the most famously dynamic relationships there, the duettino, as they sometimes called it, between Justice Ginsburg and Justice Antonin Scalia.
Ah, the odd couple of the court.
Exactly. These two, despite their polar opposite judicial philosophies, developed this fascinating intellectual sparring match, often framed as ideological combat, yet somehow always underpinned by this deep, mutual respect and even affection.
It's a remarkable relationship to consider.
Scalia, for his part, was famously known for his sharp critiques of what he saw as judicial activism. He would famously scold judges who flit from holding to holding, engaged in overreaching scolding that went beyond the bounds of the text of the Constitution or statutes.
He was a staunch textualist, an originalist, believed the law should be interpreted according to its plain meaning or the original intent of its framers, not evolve with society.
Right. And he viewed things like race-based admissions in universities as a form of reinforcing entitlement, argued the Constitution was colorblind and shouldn't permit distinctions based on race, even for remedial purposes.
And Ginsburg. She was just as quick and often just as cutting with her counterarguments, rooted firmly in a living Constitution philosophy, recognizing the need for legal principles to adapt to changing societal realities.
How does she push back on his activism claims?
Well, she'd swiftly rebut that judicial activism wasn't exclusive to one side of the ideological spectrum. She'd point to cases like Shelby County v. Holder, the 2013 case, as a clear example of activism from the right, where the court struck down a key provision of the Voting Rights Act based on its own assessment of current conditions, not purely on textual grounds.
Turning the tables on him.
Exactly. And she fiercely defended affirmative action as a necessary factor of a factor, an essential protection against the vile infection of rank discrimination in the form of racial caste. That's incredibly strong language. Vile infection.
It really is.
And she famously stated that acting as if the future is race-neutral is like an ostrich with its head stuck in the sand because it cannot stand to see what plagues our land.
Wow, that's a powerful image.
It underscored her view that ignoring ongoing racial inequalities was a willful blindness. And her exasperated retort, "What hubris? What hubris?" apparently delivered during a particularly heated exchange where Scalia suggested discriminatory practices were basically a thing of the past. It just encapsulates the intensity of their legal disagreements. Her frustration with what she saw as this ivory tower dismissal of real-world suffering.
You can almost picture the sparks flying in those debates. This vivid clash brilliantly illustrates the fundamental differences between those philosophies. Textualist originalist versus a more progressive, living constitution approach seeking equality in an evolving society.
Absolutely. A clash of titans, really.
It's clear they had profoundly different visions for the law and society. But what's truly remarkable, almost an anomaly in today's often fractured public discourse, is what happened beyond the bench. Despite these intense intellectual duels, these fundamental disagreements, there was this shared humanity, this professional esteem that transcended their ideological divides.
Yes, that's the other side of the coin.
Justice Ginsburg's poignant remembrance of Justice Antonin Scalia, whose death she called the most momentous occurrence of the court's 2015-16 term, is such a testament to this. And it offers a powerful lesson, I think.
Indeed. Her words painted this vivid, almost affectionate picture of a colleague she respected deeply, despite their often clashing viewpoints. She described him as a man of many talents, a jurist of captivating brilliance, high spirits, and quick wit. Possessed of a rare talent, she said, for making even the most somber judge smile.
That's lovely.
It is. She recounted how the press aptly described his energetic fervor, astringent intellect, peppery prose, acumen, and affability. And their shared love for opera, for instance, was well known. They frequently attended performances together, even appeared on stage as extras once.
No kidding.
Yeah, it allowed them to engage as human beings, finding common ground in art and friendship, which likely helped maintain that mutual respect despite their profound legal disagreements.
That tribute is incredibly significant then.
I think so. It highlights the possibility of deep professional respect, even affection, between individuals with diametrically opposed legal and political philosophies. It offers this powerful model for civil discourse in a deeply divided world, showing that profound intellectual disagreement doesn't necessitate personal animosity. In fact, it can coexist with mutual admiration, a dynamic that's actually crucial for the healthy functioning of institutions like the Supreme Court, where robust debate is essential.
It's a wonderful, almost heartwarming example of how, even at the highest levels of ideological contention, a shared humanity can prevail. Now, while Justice Ginsburg is rightly celebrated for her powerful dissents, her influence certainly extended beyond them.
Oh, definitely.
There was a notable case where she authored the majority opinion, demonstrating her legal acumen in shaping consensus on the court, even on issues with complex constitutional and international implications. This was the case of Bank Markazi v. Peterson in 2016, a decision upholding a statute that freed assets for distribution among judgment creditors.
Yes, Bank Markazi v. Peterson is an excellent example of her intellectual prowess in crafting majority opinions. The constitutional question involved centered on a fundamental aspect of the separation of powers.
Okay, what was the specific question?
Specifically, whether Congress could direct a particular result in a pending court case. Ginsburg's opinion meticulously carved out a crucial distinction. She firmly reaffirmed that Congress cannot dictate how a court decides a case under existing law that would be an unconstitutional encroachment on judicial power.
Right, telling the judge how to rule.
Exactly. However, Congress can amend the underlying law that is applicable to a pending case, even if that amendment effectively determines the outcome of that specific case.
So changing the rules versus changing the referee's call.
That's a good way to put it. In Bank Markazi, Congress had passed a specific law identifying a pool of assets belonging to Iran's central bank that could be used to satisfy judgments for victims of state-sponsored terrorism. Ginsburg's majority opinion meticulously explained that this was a legitimate exercise of legislative power, changing the law itself rather than telling the courts how to apply old law. It's a crucial, often subtle distinction in American constitutional law, upholding the balance of powers while also allowing legislative action to address specific societal harms.
Was the decision unanimous?
No, the decision wasn't without controversy and had significant repercussions. It drew a strong dissent from the Chief Justice, John Roberts, who was joined by Justice Sotomayor. They argued that the majority's decision effectively did allow Congress to usurp judicial functions by dictating the outcome of a specific case, blurring those lines of separation of powers.
And international repercussions, too.
Yes, and as you noted, it also provoked an irate response from Iran, leading to a suit against the United States filed by Iran in the International Court of Justice, alleging violations of international treaties.
So this case really highlights that Justice Ginsburg's influence was profound, not only in her powerful dissenting voice, but also in her ability to craft majority opinions that navigated complex constitutional questions, reaffirmed fundamental principles of governance, and had significant real-world repercussions, even on the international stage.
Absolutely. It underscored her capacity to shape law through consensus as well as through protest. A truly multifaceted jurist. Outro.
So as we wrap up this deep dive, it's just abundantly clear that Justice Ruth Bader Ginsburg's own words, whether in those heartfelt tributes to the women who came before her, in her incisive critiques of judicial overreach, or in her meticulously crafted dissents, were far more than just legal pronouncements.
Much more.
They were strategic instruments. Instruments of legal and social change, shaping the very fabric of our nation. She understood that words have power, immense power, and she wielded that power with, well, unparalleled precision, strategic foresight, and this unwavering gaze toward the future.
Her legacy is truly a profound testament to the enduring power of thoughtful, persistent, and strategically deployed words. She demonstrated that dissenting for the future isn't an act of futility, it's not mere complaint. It's a profound act of hope, really, and groundwork.
Groundwork for the future.
Exactly. A way to speak to generations yet to come, laying the intellectual and moral foundations for a justice that might only be realized decades down the line. Her quiet voice, so meticulously articulated, indeed became one of the most powerful in modern history. It reminds us all that true influence can be built word by carefully chosen word, capable of bending that arc of the law towards justice.
So, as you reflect on Justice Ginsburg's incredible journey, her unwavering commitment to justice through the power of language, I want to leave you with this provocative thought. What ancient notions or lingering injustices in your own life, perhaps your community or society at large, might benefit from a persistent, clear, and strategically voiced challenge inspired by Justice Ginsburg's own powerful example?
Where can your words make a difference?
Not just for today, but for the future. Something to think about.